Welcome to Scars of the Past Ministry. I am your host, Patty Adams, DTM and MSP. Scars of the Past is a nonprofit ministry that supports and assists victims of sexual violence. We do this through a holistic approach that allows the victim to become victorious through building faith, trust, resilience, and character. By doing this, the victims will be able to approach life with hope and be productive in their society. We are very passionate about educating our community on ways to stay safe and guarding themselves from the enemy. Our motto is "We stand against violence, we stand for freedom." Our desire is no victim will live with lifelong scars, but instead will be able to walk in the destiny that God has chosen for each of them. Our podcast today begins with a definition for statute of limitations, how the statutes vary from state to state, why it is important to know this information, and some websites of where you can get more material on this subject matter. In the unfortunate case that you or your child are the victims of a sexual assault crime, knowing the statute of limitations in your state is imperative. The information given is dry in nature because of the legalese involved, but it is well worth the listen. Trust me, you would rather take out time to familiarize yourself with this information now than after the fact. An assault may never happen to you, but it may happen to someone you love that would really be able to use your assistance. Statute of limitations are laws that prohibit prosecutors from indicting someone with a wrongdoing that occurred more than a quantified number of years. The central determination of these laws is to guarantee that convictions are grounded upon evidence, physical or bystander, that has not faded with time. After the time period has passed, the wrongdoing can no longer be prosecuted, meaning that the suspect or the perpetrator is basically free. It is important to know your state's statute of limitations because if you let this time pass, you may be unable to file a lawsuit in criminal or civil court. Most statute of limitations have a specific time in which it starts and stops or runs out. One also needs to keep in mind that statute of limitations can change from time to time. Therefore, it is advantageous to stay up to date on the most recent changes. One of the reasons this is extremely important is because a great deal of the time the victim is so traumatized by what happened, he or she cannot bear to share it with others, not even the courts. Then, typically, when they are stronger or healed from the event, they make a decision to bring charges against their assailant. It's just too late because the statute of limitations has already run out. When I first started researching this topic, I was utterly appalled at how different the law is state to state for sexual offenses, even down to what it is called. In some states, sexual assault is referred to as rape, in other states, sexual battery, and in others, sexual abuse. How does a person who does not know the law and cannot afford an attorney keep up with all of this? Each state institutes their own statute of limitations, often with distinctive time perimeters for individual types of offenses. The language used in these statutes can also be very different and can be very hard to understand. Let's take, for instance, the state of Florida where I live now and the state of Texas where I used to live. In Florida, the assault is considered sexual battery, whereas in the state of Texas, it is referred to as sexual assault. In Texas, the assailant or the perpetrator is referred to as the actor under Penal Chapter 21 through Chapter 22.2. Actor means a person whose criminal responsibility is an issue in a criminal action. Whenever the term suspect is used in this code, it means actor. That can be found under www.hg.org. So, what is the statute of limitations for rape and sexual assault in Texas? The state of Texas imposes statute of limitations or deadlines on bringing charges against someone for a sex crime. These crimes include, but are not limited to, sexual assault, sexual violence, sexual abuse of a minor, and kidnapping with intent to abuse sexually. Time is of the essence in the sex crime cases. The statute of limitations help to maintain the integrity of the evidence. Let's go ahead and answer some questions you may be asking. What is the statute of limitations for sex crimes against adults? Two types of statute of limitations exist, civil and criminal. The criminal statute of limitation in Texas for rapes and other sexual assault involving a victim who is 18 years of age or older is 10 years from the date of the offense. Let's say, for example, you were assaulted at the age of 16. You were a child, but you were afraid to share what happened. Then one day you opened up to a friend and said, I was sexually abused. As the both of you began talking, it is revealed that this incident happened in the state of Texas and that if you are 16, you cannot file charges after the age of 26. So now you are ready, but the courts are not ready for you. You will never be able to file charges against that person in the state of Texas unless their specific statute of limitation changes. Typically, when this happens, you will know because it is broadcast on your local news station. The civil statute of limitations involving victims of sex crimes that are 18 and older is 5 years. Exception to these statutes involve cases where a suspect hasn't been identified and cases that involve a serial rapist. For these situations, no statute of limitations exists. What is the statute of limitations for sex crimes against children? Texas has understandably imposed longer statutes of limitations for these situations involving children for civil and criminal cases. For criminal cases involving minors under 17 at the time of the assault, the criminal statute of limitations is 20 years from the 18th birthday of the victim. In civil cases involving minors under 17 at the time of the assault, the statute of limitations is anywhere from 10 to 20 years from the victim's 18th birthday. What is the statute of limitation for sex crimes involving unknown perpetrators? As stated above, there is no statute of limitations on sex crimes where the identity of the perpetrator is unknown. The victim can file a John Doe lawsuit in this case. But once the victim finds out the identity of the attacker, he or she has 30 days to amend the complaint to include the name of the person. I had no idea that there was such a thing as a John Doe lawsuit. So now let's look at the Florida statutes of limitations for sex crime. Each state has a statute of limitations that applies to criminal offenses. Over time, the Florida legislature has found numerous ways to limit the application of the statute of limitations in criminal cases, particularly for rape and sexually motivated crimes against children. Depending on the way the crime is charged, it is possible that no statute of limitation applies. For some of the most serious sexually motivated offenses, a prosecution can be commenced at any time. The list of exceptions is growing. The Florida legislature recently passed Donna's Law that applies to crimes committed on or after July 1st, 2020. Donna Laws creates an exception to general time limitations, allowing a prosecution to be commenced at any time for specified sexual battery offenses against children. As a general rule, the prosecution for a capital felony, a life felony, or a felony that resulted in death may be commenced at any time. In other words, these crimes have no statute of limitation. Several types of sexual battery crimes in Florida fall into this category. Sexual battery of a child less than 12 years of age under Code 794.0112A and B. Sexual battery with the use of force or the use of threat to use a deadly weapon under Code 794.0113. And sexual battery of a child less than 12 years of age by a person in a family or custodial authority under 794.0118C. Other types of sexual battery offenses that have no statute of limitations because the prosecution can be commenced at any time. A first-degree felony sexual battery committed on a victim under 18 years of age as provided in 775.1513B. A violation of 794.011 sexual battery when the victim was under 16 years of age at the time of the offense was committed, 775.1513C. A first or second degree felony sexual battery under 794.011, which is reported to a law enforcement agency within 72 hours after its commission as provided in 775.514. A first or second degree felony sexual battery under 794.011 committed upon a victim under the age of 18, which is reported to a law enforcement or other governmental agency within 72 hours after its commission as provided in 775.1513A. So as you can hear, there's a lot of codes and a lot of numbers. There's no need in putting all of this to memory. You just need to go out there and research so you'll know what it means when the time comes. In addition to sexual battery, the following sex crimes have no statute of limitations because the prosecution can be commenced at any time, such as the kidnapping of a child under 13, or when a person 18 or older commits a lewd or lascivious molestation against a child under 12, and the list goes on. There's such thing called tolling in the statute of limitations until the victim turns 18. If the victim is under the age of 18 at the time the crime is committed, then the computation of time for the statute of limitations is tolled until the victim turns 18 years of age. This provision applies to incest, sexual battery, any lewd or lascivious offense under 800.04, or computer facilitated lewd or lasciviousness exhibition under 847.013. But what about tolling, you ask? What is that? When the statute of limitations tolls, that means it has been legally suspended. In other words, the clock stops running for a certain period of time, and the 5 or however many years get further and further away. A lot of this information that I gave today was provided through statutes.capital.texas.gov. Some was under jsberrylaw.com. We will explore the court system in a different podcast, but one thing that is crucial to know if you are a victim of a sexual abuse crime is the difference between civil and criminal sexual assault. Each type of sexual abuse cases have very unique circumstances and will affect not only impending punishments, but also how much leverage the alleged accuser has over the manner in which the case advances. In a criminal case, the state controls the proceedings, with the victim acting as a witness for the state. In a civil lawsuit, however, all of the major decisions rest with the plaintiff. You have been listening to some of the rules of the road concerning statute of limitations and how they vary from state to state. The idiom rules of the road in a figurative sense refers to customary practices one needs to take to avoid potential problems. I hope that you take time to review this subject matter even closer so that you can quickly access this information if it is ever needed. Thank you for listening, and may you always be blessed.